All right, let's talk about trials. Now, as a lawyer, I can tell you that what you see on TV, it's not quite right. In fact, what a trial really is might surprise you. So we're going to pull back that curtain and get down to what it actually takes to win in a courtroom.
And we've got to start with this because it is the most important thing to get. Trial is the last chance you get to play your cards, if you have any. See, everything, and I mean everything, we're about to cover comes down to one thing: knowing what cards you're holding long before you ever see a judge. Because let's be honest, if you show up to the poker table with no cards, you've already lost the game, right?
All right, Section 1, the trial misconception, or as I like to call it, shattering the Hollywood myth. Okay, first things first, you have to forget everything you've seen in the movies. You know, the surprise witness bursting through the doors, the dramatic last-minute confession on the stand. Yeah, that's not how it works. The real thing is way less dramatic, but honestly, it's way more strategic and I think a lot more interesting.
So that begs the question, right? If it's not for all these dramatic reveals, then what is a trial actually for? I mean, why go through this whole intense, stressful process? Well, the answer to that's the key to pretty much all legal strategy.
And let me be absolutely 100% clear on this. A trial is not for discovering new evidence. It is not the time for some Perry Mason moment where a surprise witness shows up. That's pure Hollywood fantasy. By the time you get to trial, the time for finding stuff, what we call discovery, is long, long over.
And it is definitely not the time for digging up facts you don't already have. Look, if your game plan is to go to trial hoping you'll find that smoking gun in the middle of cross-examination, let me just save you the trouble. You've already lost. It's just too late. So what is it then? Think of it this way. Trial is where you tell the court what you already have in the record. That's it. It's not a rehearsal, it's the final performance. It's showtime. You're simply presenting the evidence and the story that you have spent months, maybe even years, carefully gathering and putting into the court's official record.
Which brings us to our next section, the real battleground, pre-trial. This is where cases are truly won and lost. You see, if the trial is just the big show at the end, then where's the real fight? It's not in the courtroom. It's in all the work that happens months before. The pre-trial phase, that is the real battleground. That's where all the heavy lifting gets done.
And this is your arsenal. During pre-trial, you've got these 5 major discovery tools. We're talking about things like depositions. That's where you get to question the other side's witnesses under oath, on camera, before trial. You send out requests for documents. You get all your evidence into the record. This is how you build that winning hand. And sometimes, if you do your job right, you build such a strong case that you can file something called a motion for summary judgment. Basically, you're telling the judge, hey, the facts are so clear-cut, there's no need for a trial, just rule in our favor right now.
And this really gets to the hard truth of it all. If you haven't won by the time the case is ready to go before the judge and jury, you either haven't done your best or you're not the person who should win. Oof, that's a tough pill to swallow, but it's true. The outcome is decided by your preparation, not by some slick last-minute move in the courtroom. By the time that first gavel falls, the winner has usually already been determined by the work they did months ago. Okay, Section 3, surviving the courtroom arena. Because yeah, trial is always a risk. Even if you've done everything perfectly, the trial itself is, well, it's a chaotic arena. It's a hectic, unpredictable place where things can go sideways in a heartbeat. For one thing, you've got impatient judges. Remember that slow, methodical pretrial phase? Forget it. In the courtroom, you are on the clock. Judges have a mountain of cases to get through. It's called their docket. And trust me, they are not interested in waiting around while you shuffle your papers. They have zero patience for disorganization.
Then you've got the jury. And listen, you can try to pick the perfect jury, but at the end of the day, it is always a gamble. People might have hidden biases. Sometimes they even lie during jury selection. You just never know. It's a total crapshoot no matter how strong your case is.
And the people on the stand, totally unpredictable. I've seen it happen so many times. You have a witness who was amazing during their deposition, gave you perfect, clear, helpful answers. Then they get on the witness stand with a judge staring at them, and suddenly, they forget everything. It's maddening, and it happens all the time. And then there are surprise legal arguments. This is a classic courtroom chaos moment. The other lawyer can just stand up and spring a totally new legal theory on you that you've never even heard before. And if you haven't thought through every possible angle, you can get trapped, completely flat-footed.
So how in the world do you deal with all this chaos? That brings us to Section 4, your strategic blueprint, The goal is to bring order to that chaos. You can't rely on luck. You need a plan, a clear, logical blueprint.
Look at your presentation. Is it a haphazard ramble or a convincing sequence? You can't just walk into court and dump a giant pile of documents on the judge's desk and say, "Here, you figure it out." That's a losing strategy. You have to build your case logically, step by step. Just like you're building a house. You lay the foundation, then you put up the walls, and then the roof. It has to be a clear story that flows naturally to the conclusion you want them to reach.
And here's a really powerful tool for your blueprint: the objection outside the pleadings. See, there are rules to this game, and one big rule is that the trial has to be about the issues that were laid out in the very first court documents, called the pleadings. If the other side tries to suddenly talk about something totally new, you can stand up and object. I've literally won cases on the spot with that exact objection. It can stop an opponent dead in their tracks.
You also have to remember, you can't assume anyone's paying attention. I mean, there's a famous line attorneys will say for the record, "Let the record reflect that the judge is reading a newspaper." Your job is to make them listen. Be engaging, be tactical, and make sure your most important points are not only heard, but are also officially recorded. Sometimes you gotta be a little bold to make sure your case is made.
All right, Section 5. This is so critical. The unbreakable chain of evidence. No matter how complicated your case seems, it all boils down to 3 simple links. 3. And you have to have all of them. If even one link in this chain is missing, your whole case just falls apart.
The first link is duty. You have to prove that one party owed a legal duty to the other. So, for example, a doctor has a duty to provide a competent standard of care to a patient. Pretty straightforward, right? That's your foundation. Link number 1. The second link, breach. Okay, so there was a duty. Did they break it? Did they fail to live up to that obligation? To stick with our example, did the doctor act negligently? Did their care fall below that required standard? This is link number 2, and it's usually where the biggest fight is.
And the third and final link is damages. You have to prove that the breach of that duty is what actually caused harm. Was there real damage, physical injury, financial loss, something tangible because of what they did wrong? You have to draw a direct line from the doctor's mistake to the patient's injury. That's the last link that holds it all together.
So, let's just recap that unbreakable chain. Duty, breach, damages. Simple, right? But it's also incredibly difficult. You have to connect all 3, and you have to prove each one with the evidence you gathered before trial. If you're missing the proof for even one of those links, your case is over. You lose. It's as simple as that. Okay, our final section, number 6, the winner's mindset. And this is all about you. Because you can have the most perfectly prepared, unbreakable case in the world, but if you don't carry yourself the right way in court, you can still lose. Your demeanor, your attitude, it all matters. You have to have a winner's mindset.
First up, be polite. Seriously, anger is your worst enemy in a courtroom. Having a chip on your shoulder is a one-way ticket to losing. You got to remember, judges and jurors are just people. And if they don't like you, if they don't like your attitude or your tone, it doesn't matter how right you are, you will lose. So treat everyone in that room with respect.
Next, be persistent. Look, courtrooms are high-pressure environments. I've seen even seasoned lawyers get flustered and lose their cool. Don't let that be you. You have to stick to your game plan. Know your case, know your strategy, and just calmly, persistently drive your points home, one after another. And, of course, be persuasive. At the end of the day, your job is to get the judge or jury to see things your way. And you do that by telling a compelling story with your evidence. It can't just be a dry list of facts. It needs to be believable, it needs to be convincing, and yeah, it needs to be a little emotionally appealing too. You are trying to persuade human beings after all.
Finally, and this brings us right back to where we started, be prepared. This is it. This is the whole ball game. Have your facts lined up. Know the law cold. Know your case inside, outside, and backwards. This is what separates winners from losers. Preparation isn't just important, it's everything.
So now you know. A trial isn't about finding the cards, it's about playing the hand you already hold. Which means the real question isn't how will you act at trial. The real question is this: what are you going to do before trial to make sure you walk into that courtroom with a winning hand? That's what it all comes down to.